Auctions and tenders. Are they offer or invitation to treat? Auctions are generally governed by the same rule as a display of goods in a shop window. There are two types of auctions. Auction with reserve is where the minimum bid is set and the minimum price must be met. Auction without reserve is where the item is knocked down to the highest bid. Display here is made in the auction room or an internet site. eBay, the auctioneer, acts as your agent and only makes an invitation to treat. Bidder makes the offer. Highest offer is accepted in the case of auction without reserve. Auctioneer can withdraw the goods at any time before a bid is accepted. In British car auctions versus Wright, 1972, auctioneer was convicted of making an offer to sell an unroadworthy car, contrary to the Road Traffic Act 1960. His appeal was allowed on the same ground as Partridge versus Crittenden and Fisher versus Bell. What was that ground? When an issue related to auctions is in front of you, it is also important to consider auctioneer's capacity. Auctioneer, while working as an agent of the seller, makes an invitation to treat. Auctioneer, working in personal capacity, actually makes an offer. What if the seller removes the item after the highest bid, but before the auctioneer accepts it? Seller in this case is under no obligation, as the auction was an invitation to treat. Auctioneer, on the other hand, may be obligated to sell as he made an offer to sell to the highest bidder in his personal capacity. Another situation where you must distinguish between an offer and an invitation to treat is a request for a tender. Again, it is a presumption that a request for tenders is an invitation to treat. Tender itself is an offer to buy the goods at the tendered price. In Blackpool Aero Club versus Blackpool Council 1990, defendant had invited 7 parties to tender for a concession to operate pleasure flights from the airport. Defendant's invitation prescribed a clear, orderly, and familiar procedure for tendering, and also indicated that we will consider all offers made before a specified date, and late tenders will not be considered. Claimant submitted tender in accordance with the defendant's regulations. However, defendant's designated box into which the claimant's tender was placed within the deadline was not emptied until after the deadline. Therefore, the claimant's tender was not considered. General presumption applied here that the counsel, who was the defendant, just made an invitation to treat, and the flight club, the claimant, made an offer which was never accepted by the defendant. However, interestingly, the defendant was held to have made a separate offer to consider all tenders which were posted before the deadline. The claimants accepted this offer by posting their tender before the deadline. The council breached this collateral agreement because it did not even consider the club's tender.